Transfer of Property Act 1882. Our today's topic is Doctrine of Holding Out or Transfer by Ostensible Owner. To understand the provisions of transfer by ostensible owner better, the first thing we'll do is understand who is an ostensible owner. What is the meaning? The word ostensible literally means apparent or seeming. Means it appears to be something, it seems to be something, it is not exact. An ostensible owner is a person who appears to be the owner of immovable property even though he is not the real owner of the property. For example, a person purchases a property not in his name but in the name of B. A pays the consideration but the title is in the name of B. In such case, A may be the real owner but ostensible owner is B. The provision regarding transfer by ostensible owner are laid down, governed by Section 41 of Transfer of Property Act. Now let's see what Section 41 has to say about ostensible owner. Where, with the consent expressed or implied, the consent may be express or implied, of whom the person interested in immovable property. I beg your pardon. The person interested in immovable property. Who is he? He is the real owner of the property. With his consent, a person is the ostensible owner of such property and transfer the same for consideration. Here is the important word, consideration. The transfer must be for consideration. In such case, the transfer shall not be voidable on the ground that the transferor was not authorized to make it. There is a proviso added to the section, provided that the transferee, after taking reasonable care to ascertain that the transferor had the power to make such transfer, had acted in good faith. The transferee must have taken reasonable care to make sure that the transferor has the power to make such transfer. So here are the keywords: consent. Whose consent? The person interested in immovable property. How shall the consent be? The consent must be either expressed or implied. Consent for what? Another person to become the ostensible owner of his property. Transfers the property for consideration. If these conditions are satisfied, the transfer shall not be voidable on the ground that the transferor was not authorized to make it. Right of the transferee is protected. But for such protection, there is a proviso given here. The proviso is the transferee must have taken reasonable care to ascertain that the transferor had the power to make such transfer and he has acted in good faith. The concept of transfer by ostensible owner is based on two principles. First, nemo dat quod non habet. According to this principle, it means no one has the right or power to confer or present a higher right over a property than what he himself actually possesses. Second, nemo plus juris and alium transferi protest quam ipsa habet. According to this principle, no person can transfer a title or right over a property greater than what he himself has. So what we studied is not exactly what this says, it is just opposite. Hence, the transfer by ostensible owner is an exception to these two principles. The ostensible owner, he is the apparent owner, he is not the real owner, yet he is able to give a better title to the transferee. The right of the transferee is protected. If transferee has taken reasonable care, his title is good, is not disputable. Now let's see what are the essential ingredients of section 41. The real owner shall be bound by the transfer of immovable property by the ostensible owner if the following conditions are satisfied. What are the conditions? First, the transfer of immovable property must have been done by the ostensible owner. The ostensible owner should have transferred the property. How? The transfer must be with express or implied consent of the real owner. The consent must be expressed or implied by the real owner for such transfer by the ostensible owner. Of course, the consent must be free. Free consent will have the same meaning as defined in Indian Contract Act. Third, the transfer must be for consideration. There must be a consideration for such transfer. It cannot be for free. Gifts or donations are not applicable for this rule. Next, the transferee must have acted in good faith. The transferee must have acted in good faith. He must not know that the transferer is not the real owner. He must believe that transferer is the real owner and has the power to make such transfer. Fifth, the transferee must have exercised reasonable care in finding out the transferer's power to make such transfer. The transferee should have taken some steps, reasonable care, to know the authority of the person making such transfer. If after such reasonable care he understands that the transferer has the power to make such transfer, then this ingredient is satisfied. If all these 5 ingredients are satisfied, conditions are satisfied, then the transfer made by the ostensible owner to such transferee is valid. It cannot be disputed. It is protected. Rule of estoppel. What does rule of estoppel has to say in this doctrine? Who is estopped? Here the real owner is estopped. The 5 ingredients that we studied earlier, these 5 ingredients, if these are satisfied, the real owner would be prevented. Prevented means stopped here. Stopped from disputing the validity, from challenging the validity of the transfer on the ground that the transferer, that is the ostensible owner, was not in fact competent to make such transfer. The transfer will be protected because everything has been done with the consent of the real owner. So the real owner would be stopped from disputing such transfer. Next, burden of proof. The burden of proof shall be on the transferee to prove that the transferer was actually the ostensible owner and had the consent to sell such property. Also, he has to prove that he acted on good faith and has taken all reasonable cares that was required by him while taking such property from the transferor. This is because he has to prove that he was not at fault while taking such property and to shift the burden on the real owner. These rules are laid down in Ram versus Muktikant, AR 1956, and Gurbaksh Singh versus Nikka Singh, 1963 SCR. In these two cases, detailed explanation has been given regarding burden of proof. Ramkumar Kundu versus McQueen. This is the most important and landmark case relating to transfer by ostensible owner. Let me just explain the brief facts of the case, and what court held is on the screen. In this case, the plaintiff had inherited a property by way of will. But later he came to know that someone else had already purchased this property in her name and subsequently sold this property to a third person by making him believe that he had good title over that property. The whole transaction was a Benami transaction, but was not known to anyone except the person who sold the property. The plaintiff sued the third party for recovery of possession, and the court held that it is a principle of natural equity which must be universally applicable, that where one man allows another to hold himself out. Here, hold himself out. That's where doctrine of holding out comes from, the name. As the owner of an estate, and the third person purchases it for value. For value means for consideration from the apparent owner. From the apparent owner means the ostensible owner, in the belief that he is the real owner. The man who so allows the other to hold himself out, here the man is the real owner. He allows himself to be held out. In such case, he shall not be permitted to recover upon his secret title, unless he can overthrow that the purchaser by showing that either he had direct notice or something which amounts to constructive notice of the real title. How can the owner get the property back? If he shows that the purchaser had direct or constructive notice that the transferor is not the real owner is someone else. If this is shown in the court, proved in the court, in such case the right of the real owner will be protected. If not, the transfer shall be held valid. Another important case is Jai Dayal Poddar versus B.V. Hazara. In this case, Supreme Court has laid down few considerations to check out if a transfer has been made by an ostensible owner or not. So the first condition is source of purchase money. The ostensible owner sold the property, but from where did the money come from? Where did the money go? Source of purchase money has to be taken into consideration. The second is nature of possession of such property after the purchase. Who keeps the possession? The real owner or the apparent owner? Motive for giving Benami color to the transaction. Why was such Benami transaction made? What was the reason for making the property, purchasing the property in someone else's name? The relationship between parties. What is the relationship between the real owner and the apparent owner? Conduct of the parties in dealing with the property. How are the parties dealing with the property? Who is enjoying it? Who is just the name behind the property? Who keeps the custody of the title deeds? After taking into consideration these few things, it can be decided whether a person is ostensible owner or not, whether a transfer is ostensible transfer or not. Next is Benami Transaction Act. What is its relation with transfer by ostensible owner? While going through the provisions relating to ostensible owner, transfer by ostensible owner, I uttered the word Benami few times. What does this mean? Benami literally means no name or without name. The real owner's name is being hidden. There is an ostensible transferor. His name is coming to the front. From that comes Benami. Benami Transaction Act What was its purpose? The Benami Transaction Act prohibits the transfer of property by ostensible owner. So, it says exactly the opposite. Transfer by ostensible owner is given a validity under Section 41, but under Benami Transaction Act it is prohibited. Let's study more about it. These are referred as Benami transactions and has been termed illegal. The property held by the real owner in the name of Benami owner is liable to be acquired by government. So, if government has to acquire the property, what has Section 41 of Transfer of Property Act to do? What is the meaning of existence of such provision? There are certain exceptions of Benami Transactions Act. Those exceptions are governed under Section 41 of Transfer of Property Act. So let's study what are those exceptions. The first exception is property held by the Karta or any member of Hindu undivided family for the benefit of co-personers. A Karta is holding a property or any member of Hindu undivided family. The ownership may be of any other members, but it is being held by the Karta and it is for the benefit of the co-personers. In such case, Benami Transaction Act 1988, which is now Benami Transaction Amendment Act 2016, is not applicable. An individual who buys property in the name of his spouse or his children, that is a typing error, that is not of, that is or his children, in such case Benami transaction will not be applicable. Property held by jointly by brothers or sisters or lineal ascendants or descendants. Lineal ascendants or descendants means straight up or straight down, means generation wise, straight up, father, grandfather, and so on, and descendants. The property that is held by a trustee or other person who in a fiduciary capacity has the benefit of another person for whom he has a trustee. A trustee holding property of a trust or any other person under fiduciary capacity, in such case also Benami transaction shall not be applicable. Conclusion. So after going through all the slides, all the materials that we have, what do we conclude? The theory of ostensible ownership is subject to provisions of Benami Transaction Act. Benami Transaction Act prohibits transfer by ostensible owner, but the exceptions of Benami Transaction Act are governed by rules of transfer by ostensible owner. After analyzing different case laws and concept of ostensible ownership, we reach to a conclusion that ostensible ownership is a concept that derives its authenticity and legitimacy from the ideas of equity and natural justice, meticulously the doctrine of estoppels. It holds an exception to the doctrine of nemo dat quid non habet, as it does, for reasons of equity, allows ostensible owner to deliver the right of true ownership to the bona fide transferee. The right of the bona fide transferee is being protected here. So that's it for ostensible owners. Thank you.